Hello, everyone. Good afternoon. My name is Erik Perez. Welcome to the HOA Q&A session. I'm going to be sharing my screen now for the PowerPoint presentation. Bear with me just one moment.
Hello, Mr. Perez, can you hear me?
Hello, everyone. Welcome to the Q&A session. So this is an opportunity to answer questions pertaining to HOA and condo law. Before we get started, I want to do a little bit of an introduction as to who we are as a law firm and who I am. My name is Erik Perez. I'm one of the co-founders and one of the shareholders here at Perez Mayoral, PA. I lead the firm's HOA and condominium litigation practice, representing homeowners and unit owners in disputes with associations. We also do some business litigation and real estate litigation as well, which kind of go hand in hand with the HOA disputes. And one of the things that makes our law firm uniquely suited to represent homeowners is that I personally have a history of doing the exact opposite. I represented associations for many years and communicated with the board of directors and property managers and association vendors for the purposes of representing essentially the association in their daily issues that arise with vendors and homeowners and many other parties that deal with associations. I and all of our attorneys have a background in that field. We stay current on all association law changes, and many news outlets will reach out to us for comments. So we are very involved in the association world. We are dedicated to representing homeowners and only homeowners as it pertains to HOA disputes. We do not represent associations, so we only sue for homeowners against associations or defend homeowners when they're involved in a lawsuit with their association. So these are our practice areas. As I mentioned, they kind of go hand in hand with each other. Many HOA issues often have commercial issues intertwined, and sometimes they have real estate issues intertwined as well. So what you'll find is that there's a lot of overlap between the statutes pertaining to associations such as 718, 719, and 720 as well. And the Florida Corporations Act, for instance, the Not-for-Profit Corporation Act, Florida Chapter 617, does have some components that affect association law, and then real estate issues may also arise within the representation of a homeowner against an association. So all these three kind of go hand in hand, and we have a substantial background and knowledge and understanding of these three areas of law, and we utilize all three of them when representing homeowners. So I want to lay out what we will be doing today, the instructions and how this will be done today. This is very exciting. This is the first ever Perez Mayoral Q&A session. So you are the first guests to one of our Q&A sessions, and we hope to be doing many of these in the future. So if you have friends or family members or colleagues that were unable to join today, the good thing is that we will be definitely doing them in the future. And also, this will be recorded, so we will be posting this on YouTube as well. So we have many questions to get to. We'll try to get through all of them. If we can't get to them, we will be sure to set up another Q&A. And definitely we want to make sure to answer everyone's questions. So that is very important to us. So we'll begin by answering several questions that were submitted in advance. I have about 5 questions that were submitted. And also, once those are covered, and I anticipate there may be some questions that are asked that may overlap with questions that are asked after. So there's a lot of repetitive issues that occur within the association context. So I anticipate we'll be able to cover a lot of ground today and get through many, many questions. So we look forward to covering as much as we can. And once we cover the first 5 questions, then we're going to open up the floor to live Q&A. So those of you that are here will be able to ask a question, and I will answer the question live. Questions will be addressed in real time as time allows, so we hope to get through as many questions as possible. Okay, so without further ado, let me jump into the first 5 questions that have been posed in anticipation of today's meeting. Okay, so the first question from Felicia asks, How to address when rules and regulations were never voted on by 2/3 of the homeowners. So that's a good question. And let me explain a little bit of background as to how associations work. Because to answer that question, you have to have a little bit of foundational knowledge as to how associations work and what rules and regulations are and what bylaws are and what the covenants are. So let me explain what all of those things are, okay? Within an association, and in Florida, there's essentially three different types of associations. There's condo associations, there are HOAs, homeowners associations, and there are co-ops, okay? Within the state of Florida, as it pertains to associations, there are essentially three different types, two types of authority that apply to the situations, okay? The first authority is the statutory authority, okay? The statutory authority depends on what type of association you live in. Okay, so if you live in a condominium association, the statutory authority that applies is Florida Statute Chapter 718. Okay, if you live in a co-op, the statutory authority that applies is Florida Chapter 719. If you live in an HOA, in a homeowners association, the statutory authority that applies is Florida Statute Chapter 720. So the beginning of any analysis related to a homeowners or a community association dispute begins with identifying what is the appropriate statute, okay? The statutes intentionally do not address all issues that can happen within an association, okay? And that's, as I mentioned, that's done on purpose. The reason why is because all associations are a little bit different. Some associations are condo associations that are 3 floors. Some associations are condo associations that are 60 floors. Some associations have a pool and a clubhouse. Some have a gym. Some don't have any of those amenities. Some have a security guard tower. Some have parking. Some don't have parking. So every association, whether it's an HOA, COA, or co-op, is a little bit different in the way it was developed by the developer. So what do you look to if the statute does not address the legal issue that you are presented with? Well, you look to the covenants, okay, otherwise known as the governing documents. The governing documents and the covenants essentially include all of the contractual obligations that the association and the homeowners have, okay? The governing documents are a contract between the homeowners, between themselves, and between the association. Okay, they are a binding agreement between all of the parties in the community association context. Okay, so the covenants and or the governing documents will include the bylaws. It will include the declaration of the association. It will include the covenants of the association. It will include the articles of incorporation of the association. And all of those are created at the inception of the association. So when the developer is putting together the association, one of the things that their attorneys draft are the covenants of the association. Now, those do not have to be voted on, okay? Simply by buying a unit at the association, you are essentially signing the contract and becoming a member of the association and agreeing to be bound by the terms of that particular association. However, the governing documents can be amended from time to time, okay? And there is a statutory process to amend the governing documents that's allowed by the different types of community associations. And generally speaking, depending on the type of association, generally speaking, there is a process, and the process will require a majority usually vote on amending the governing documents. Now, depending on what your governing documents provide, it may be a higher threshold. It may be a 2/3 vote, okay? Sometimes even higher than that. So to answer the first question, how do you address when the rules and regulations were never voted on by 2/3 of the homeowners? Well, the rules that apply in your association or whatever is recorded in the public records as the governing documents of the association and whatever the statute says. So nothing needs to be voted on there. However, if the board is trying to apply new rules that are not in the governing documents or are not in the statute, then they do need to pass an amendment. And that happens all the time. I see that all the time where a board of directors will essentially create a new rule within the community. It will not be voted on. It will not be passed. It will not be recorded in the public records. And according to the law, that rule would not be a rule that the homeowners are required to follow. It would essentially be an improper amendment to the governing documents because there was no notice, there was no meeting, there was no vote, and there was no recording of the governing documents or the new governing document, which is required by the statutes. Okay. Second question, what sections of Chapter 718 apply to commercial condos? The answer to that is all of Chapter 718 applies to commercial condos. Okay. Within an association, particularly within a condominium associations, many, and more recently, this is becoming even more common, within condominium associations, the buildings are being developed as mixed use buildings. Okay. So what does that mean? One of the new concepts in developing buildings is what's known as live, work, play. You want to create a building where you can live in, where you can work in, and where you can enjoy the amenities. Okay, so many of these buildings now, and the way they're being developed, will have a gym, will have a pool, will have a workspace, will also have restaurants and bars and things of that nature. And so what applies to these buildings if you are an owner of commercial property? Well, all of 718 applies. Okay, Florida Chapter 718 is known as the Condominium Act. If you own a unit in a condominium, as I mentioned earlier, you are bound by the terms of the statute, Florida Chapter 718, as well as by the terms of the governing documents of that association. Okay, the next question is, can they impose fines without disclosure? Okay, can associations just keep adding fines without knowledge? The answer to that question is a resounding no. Okay, associations do that all the time, unfortunately, and they absolutely can not impose fines without following the procedure in the statute. Okay, within the statute and within 718 and 720, it's very similarly worded, but essentially what the legislature anticipated is these types of things happening. So what they did not too long ago is they included some sort of due process for the homeowners so that they don't face these sort of situations. And what the statutes provide essentially is that if the association wants to impose a fine on a homeowner, they must, number one, notify the homeowner. There needs to be some sort of notice. You need to send correspondence to the homeowner, notifying them of what the violation is. Okay. Second, the association must have an impartial violations committee. Okay. The violations committee cannot be members of the board. It can't be someone that's married to a member of the board. It cannot be a child of a member, an adult child of a member of the board. It needs to be a truly impartial committee that has no relationship to the board, nor does this person work for the association. So it needs to be an impartial body, okay? And that impartial body needs to have a hearing with the person that is being alleged to have committed a violation and the person that the association is intending to fine. Okay, so if the association does not follow this protocol, they cannot impose a fine, and they are imposing an invalid fine if they are asking you to pay a fine and they have not followed this procedure. It happens all the time. I see it happen all the time. And in those situations, you have to notify the board, this is an improper fine and I should not be paying this fine. And if you force me to pay this fine, I'm going to have to essentially sue the association to invalidate the fine. So that is something we come across all the time. The next question is, what is the best way to handle a board and property manager that constantly violate the declaration of covenants and restrictions? Okay, so as I mentioned earlier, the covenants are a contract. Okay, so if a board or a property manager on behalf of the board is violating the covenants, the association through the board is in breach of contract. Okay, it's important to understand a distinction here. Okay, a lot of people are confused about what the role of the board is and what the role of the property manager is and what the association is. So I'd like to take a moment to explain that, because that is very important. Okay, the association, whether it's an HOA or COA or co-op, is a corporation. Okay, it's a not-for-profit entity. Okay, much like any other corporation. Okay, so for instance, Coca-Cola or Amazon or Walmart. Okay, just like any other corporation, there needs to be people that run the corporation. And within an association, the people that run the corporation are the board of directors. Okay, the president, the vice president, the treasurer, the secretary, these are the people that lead the corporation. Okay, they are individuals that make decisions for the corporation within the bounds of the statute and the governing documents. Okay, so the property manager is a third party. Okay, the property manager, much like the association's counsel and attorneys, okay, they are third parties that carry out the instructions of the board. Okay, so when an association is doing something and you believe, and if you believe what they are doing violates the covenants of the association, okay, the entity itself, the company, is in breach of contract. Okay, although those directions come from the board, the party, generally speaking, that is liable is the association as an entity. Now, sometimes a board member or property manager may do something that is outside of the scope of their role. So it's not uncommon, for example, for sometimes when there's an ongoing heated situation where, for example, a board president and a homeowner may get into a physical altercation. Well, under those sort of circumstances, the association as a company, may be liable, but that individual board president who caused a physical altercation may himself or herself also be liable. Okay. Similarly, same thing with a property manager. If a property manager does something outside of the scope of the property management or acts in a way that is contrary to the board's instructions and causes damage to a homeowner, well, that property manager may be liable. Just recently, in the news, there's a news article that came out this month wherein an association property manager was sued. And what the complaint alleges is that the property manager's mother was actually acting on behalf of her daughter, who was the licensed property manager. So the mother, it appears, was either impersonating or acting on behalf of the daughter, who was the actual property manager of the association. And because of the actions that the mother was taking, the homeowners were harmed substantially. And ultimately, that case was litigated over about 2 to 3 years. And just recently, the jury entered a verdict in excess of $6 million, of which part of that was the responsibility of the property manager for what occurred. So sometimes the property manager can be individually liable to the homeowners if they take certain actions that damage the property. Most of the time, the party that's going to be liable is going to be the actual association as a corporation as a result of the decisions made by the board. But the best way to answer the question, the best way to handle these sort of issues, it depends on what type of association you live in, but ultimately the association would be in breach of contract. And depending on the type of dispute, you may need to either send a pre-arbitration notice and threaten DBPR arbitration, or you may need to send a pre-suit statutory offer to mediate and mediate the dispute with the association, or you may be able to simply sue the association for the damages they have caused. There's dispute resolution clauses in the different association statutes. For instance, in the condominium context, it's going to be 718.1255. In that statute, you will see the different types of disputes and what you have to do to escalate those types of disputes. So it's important that you look at the dispute resolution statute, depending on what type of community you live in, and then proceed with whatever the statute calls for if you wish to escalate the dispute and hold the association or the board members or the property manager liable for their breach of the covenants. Okay. The next question is, are management companies liable for damages if they fail to advise associations about violations of laws or regulations? That is a very fact-specific question. It's going to depend on what happened exactly, okay? Within the association context, as I described a moment ago, at the end of the day, what the property manager is doing is essentially carrying out the orders of the board. Now, of course, if the property manager is asked to do something illegal, okay, and the property manager carries out an act that is illegal, that property manager certainly could be held liable for the actions that the property manager has taken. However, generally speaking, the property manager is taking directions from the board, and the board is taking actions for the association. So generally speaking, the primarily liable party in most association versus homeowner disputes is going to be the association itself as an entity. However, as I mentioned earlier, sometimes the property manager may be acting in a way that is not complying with the association's board's instructions, in which case the property manager could be liable. Or as I mentioned, the property manager could be carrying out something illegal, in which case the property manager also could be liable to the homeowner if they have caused the homeowner any sort of damages. So it's important overall, it is important in any homeowner dispute to identify, number one, who is the party causing the harm? Is it the board? Is it the property manager? Is it the association as an entity? Okay. And then number two, what type of dispute is it? Okay. Once you identify what type of dispute it is, you can review the statute to identify how to escalate the dispute. And as I mentioned, sometimes it's going to be a letter that you have to send warning them about the potential for arbitration. Sometimes it's going to be a letter you have to send offering mediation. Sometimes you can go right into a legal proceeding and file a lawsuit against the association for violating the covenants or violating the statutes. It's important to do that analysis when you are considering escalating these sort of disputes. And the reason why, really the primary reason why, is because all of these statutes, 718, 719, 720, and almost always in the covenants as well, there is an attorney's fees provision. Okay, so what that means is in these disputes, once they go into court, like any other case, if it doesn't settle, there's going to be a winner and there's going to be a loser. The losing party will have potentially to pay the winning party their attorney's fees. Okay, so the winning party can obtain entitlement to reimbursement of their attorney's fees, and ultimately the losing party may need to pay the winning party their attorney's fees. So it's important that before you file a lawsuit, you make sure you have a legitimate claim. Okay, you make sure you file it in the right court. You make sure you comply with the prerequisites to filing, because if you're hit with a motion to dismiss and your lawsuit gets dismissed, now you're looking at not only losing the case, but you're also looking at attorney fee exposure and having to pay the winning party their attorney's fees. So let's jump into the live Q&A questions. I'm sure there's many out there. Go ahead and ask your questions. There's a Q&A box that should be on your screen. Okay, and I'll remove the share screen, and maybe a little bit easier to see once I remove the share screen. But please go ahead and type in your question, and Catherine will be going through the questions as they're typed in and asking me the questions, and I'll be answering all the questions. So if you have any follow-up questions on anything that I answered here on the 5 preliminary questions, or if you have something completely different than you would like to ask, please go to the bottom of your screen where it says Q&A, and please ask your question in there, and we'll wait for Catherine to jump on the screen and select a question.
Thank you, Erik. We've already received a couple of questions, so let's go ahead and get started. Joseph says, equal justice for condos. For example, if several owners are renting without board approval and you have filled with board, but now since rules have been relaxed, would the board have to bring legal action against all?
So, as I mentioned earlier, as it pertains to rules within a condominium association and any changes to the rules, okay, you need to look to the governing documents to what it says about amending the declaration. Oftentimes, as was alluded to in the question, many rules pertain to renters, many rules pertain to Airbnb, several restrictions on those that I've seen in governing documents of associations. And basically, you need to look to them to see what they say. If the board is trying to amend the rules, you need to make sure they comply with the statutory process. As it pertains to what homeowners can do in these situations, if you're being restricted by an association from doing something, you need to make sure that it is in either the statute or the governing documents, okay? Because ultimately the association can escalate the dispute by either sending you a pre-arbitration notice, sending you a statutory offer to mediate letter, or suing you to receive injunctive relief, or ultimately suing you for monetary relief if your actions have caused harm to the association. So the association, and specifically the board, does have a duty to hold everyone accountable and apply the covenants in the association. If a homeowner is violating the covenants, the board's job is to take action and to enforce the covenants in the community against the homeowner. So just like association homeowners should confirm that the association itself as an entity is complying with covenants, boards will do the same thing back to us, the homeowners, and make sure that the homeowners are complying with the covenants as well. And you need to be very aware of what your covenants say and avoid violating them. And if you believe that there's something unjust in the covenants and they should be amended, you should consider either running for the board to have yourself set up in a position where you can get more attention from the homeowners and move to try to amend the governing documents. So that is important to know. And once again, always verify what your covenants say. If it's not in the statute or not in the covenants, the board likely cannot do it. Vice versa, same thing, a homeowner likely cannot do it. So let's jump into the next question.
Valerie asks, if a person is in a lawsuit with the COA, is the association obligated to provide documents in relation to the lawsuit through an official records request?
So that's a very good question. We come across that all the time. So the statutory records request is different from a request for production. Okay, so once you're in litigation, you don't even really need the statute. If you're being sued by the association, or if you're suing the association, you can send what's called a request for production and request association records. Now, you're confined to the bounds of the lawsuit. So if your lawsuit is about an ARC violation involving a change to or an addition of a fountain to your front lawn or whatever the case may be, you can request production, but you can only request production related to the issue that's in the case. You can't start asking about financial records of the association. You can't start asking about vendors of the association. So you're limited to what is relevant to that lawsuit. However, under the Condominium Act, as most may know, there is an ability to request records. And the way you can request records is by sending it in writing to the association and asking for an inspection. Now, that is very broad, okay? And the statute essentially provides anything that is relevant to running the association. I'm paraphrasing here, but that's kind of the gist of it. Anything that is relevant to running the association, the homeowners have access to. So outside of the litigation, if you simply want to send a request for an inspection of records, that is much more broad, much more all-encompassing, and the association has an obligation to produce all records for inspection, okay? And so you can exercise that right as well, and you don't have to be in litigation to exercise that right. You can exercise that right at any time, before a lawsuit is filed, while a lawsuit is filed, after a lawsuit was filed. Once you send a written request for records, the association has 10 business days to coordinate producing them. And if they do not do that, ultimately, there is a fine that is imposed. It's $100 a day up to 10 days, so they can be responsible for up to $1,000. And if you sue them, as I mentioned, these disputes have association attorney's fees attached to them. So if you sue them, ultimately, they may have to cover your attorney's fees for suing them.
The next question is from Kimberly. She asks, if the condo declaration clearly lists drainage and stormwater management systems the responsibility of the COA, if the COA refuses to fix a water intrusion until I install gutters at my expense, can the board still be cited for extortion?
So extortion would not necessarily be the correct cause of action as it pertains to that case. So in these cases of maintenance, this is essentially a maintenance dispute. In these cases of maintenance, you have to identify what is causing the damage to your home, okay? If what is causing the damage to your home is something the association is responsible for maintaining, okay, they cannot turn around and tell you, hey, you need to do something before I do my own maintenance. It doesn't work that way, okay? The association is liable if they do not maintain the common areas or areas they're responsible for maintaining. And as a result of their failure to maintain, your home is damaged, the association is liable for that, okay? And we represent hundreds of homeowners in those types of situations. When an association is not maintaining what they need to maintain and your home is being damaged, you can absolutely sue the association. What I see often in these situations is, for example, let's say you live in a condominium association and you live on the top floor and the roof is leaking, okay? And water is coming in from the roof down into your ceiling, down through the drywall, all the way to the flooring, and causing tens of thousands of dollars of damage. Okay, and as a homeowner, you call the association or their property manager and say, hey, I need help fixing this. What they will tell you to do 99.999% of the time is, that's not our problem. Call your insurance company. They'll fix that for you. Well, why should you be the person to face an increased premium? You know, you may call your insurance company, they may fix it, and now next year your premium goes up $500, $1,000. I've seen as high as $9,000 from one year to the next after making an insurance claim. So your insurance is not intended to be used for those types of things. Your insurance is intended to be used for any damage that you may cause to your property, or potentially some accidental occurrence that causes damage to your property, not when it's negligence of the association or the association's failure to maintain. So if the association is not maintaining something they need to maintain, they are absolutely liable for it. As a matter of fact, those particular cases, liability is often very clear, and we actually offer, in some instances when the issue involves property damage, we offer representation on a contingency fee basis so that you can recover all the damage that you need to repair your home. So when it comes to the association causing a water intrusion, they are liable. They need to pay for the damages. They need to repair the common area, and ultimately they can be sued for that and have to pay you for your damages. And we represent hundreds of homeowners in those situations.
The next question is from Brian. He asks, how do we manage a situation where the board is run by a developer who owns a majority of the property and is violating the covenants?
So the answer to that question is a little bit tricky because it's going to depend on the turnover of the association. So there's a process wherein an association is created by the developer. Okay, the developer constructs it. Okay, people start buying the properties. Okay, the different units within the association, and ultimately, at some point, depending on what the governing documents provide, the developer will complete what's called the turnover process, which is where essentially the developer will step down and hand the property off to the corporate entity that is the association. Okay, so it's going to depend where in that process you are as a homeowner, but ultimately, as I mentioned, the covenants are a contract between the homeowners and the association. Sometimes the developer will stay on the board after the turnover process because the developer will hold on to the majority of the units and have a sufficient amount of votes to stay on the board. So to answer the question, generally, it's going to depend on what phase of the process you're in, but generally, if the developer is violating the covenants, the developer could be in breach of contract, and you may need to sue the developer for any damages that you as a homeowner have sustained as a result of the actions of the developer. And the defendant in that case is going to depend on where you are in that turnover process. Also, you're going to have to identify what your damages are within the association context. There is some overlap between Florida corporate law and Florida association law. And within an association, within association law, there's a well-known case called the Ayezi family case. Okay. And essentially what that case says is that if the primary harm is to an individual, okay, then the individual can sue. But if the primary harm is to the association, then you need to sue in what's called a derivative capacity, meaning you need to, as a homeowner, step into the shoes of the association, okay, and sue for the association. Okay, it's going to depend a lot on what the facts of the case are, but many times when it comes to these developer versus homeowner disputes, you may need to file in a derivative capacity, but it's going to depend on the facts of the case.
Lou asks, how many open meetings must an HOA have with their residents per year?
So really, by statute, the only meeting that is required is the annual election meeting. Now, in practice, most associations will usually have maybe 2, 3, sometimes a little bit more than that, but oftentimes right around in that range. They'll have about 2, 3, 4 meetings a year. So they will have their annual election meeting. Oftentimes the budget meeting is done immediately after the election meeting. You can count that as a separate meeting, but it's usually done immediately after the election meeting. And thereafter, for instance, if there's any special assessments, though, there needs to be a special assessment meeting. If there are any open board meetings, and really the only meetings that should be closed board meetings are meetings with the board and the association's attorney. And the reason being is that the information discussed is attorney-client privileged. At the end of the day, although the attorney represents the association, the attorney for the association does not represent the homeowners. Really, the attorney represents the company, and that, as I mentioned, that company is led by the board. So in a way, the board is the client of the attorney. And so those meetings are closed meetings. Everything else should be an open meeting. Unless your declaration or your governing documents provide otherwise, there isn't necessarily a requirement as to how many meetings there should be. Generally speaking, you need the election meeting, you need the budget meeting, and there will be oftentimes at least a couple more meetings to inform the homeowners of things that are ongoing within the community.
Chinnery asks, what type of disputes involving litigation against an HOA tend to favor homeowners in which the homeowner prevails? What are the factors that increase the chances that a homeowner wins a lawsuit against an HOA?
That's an interesting question. There certainly are cases that have a higher probability of success, and then inversely, and I'll discuss this as well, there are also cases where the homeowner has a very low chance of success, and I'll go through those as well. So in terms of cases that have a high probability of success, as I mentioned earlier, failure to maintain, if the association hasn't maintained the roof, hasn't maintained the exterior wall, hasn't maintained the pipes, and water comes into your home and damages your home, those cases are usually pretty cut and dry, pretty high probability of success for the homeowners in those sort of cases. So as it pertains to those sort of cases, I would say that there's a good chance of prevailing in those cases when it comes to the association failing to maintain. Also, when an association fails to properly or even at all conduct an election, okay, the statute in all community associations types and the different chapters in Florida, the statutes are very clear on what needs to be done for an election. Okay, if an association does not comply with the statute as it pertains to elections, homeowners have a very high probability of success in those situations. So election disputes, maintenance disputes, another type of dispute that has a high probability of success are recalls. Once again, the statute is very clear. A recall is the process to remove a board member. If you obtain the requisite votes or signed petitions for a recall, ultimately in the board, if the board does not step down after you present to them the valid petition for a recall, you have a very high probability of success at a DBPR arbitration once you show the arbitrator the petition and the signatures. So I would say recalls, I would say election disputes, I would say maintenance disputes, I would say records disputes as well. Statute is very clear there. If within 10 business days you do not produce the records that you're required to produce to the homeowner upon a written inspection of records, you have a very high success or chance of success if you escalate the dispute legally. In all of these disputes that I've just described to you, when we've represented homeowners, we've been able pretty much almost always to obtain the result they're seeking and recover attorney's fees. So all of these types of disputes have a very, very high probability of success. Okay, so let's discuss briefly the ones that have a low probability of success. And I would say that there are certainly a couple cases that are very difficult to prevail on. And I'll explain to you why as well. Okay, special assessment disputes are very difficult to prevail on. Okay, there are ways to invalidate special assessments, and we've done it many times. Okay, the statute identifies a procedure, and oftentimes associations don't follow the procedure. We file a lawsuit and we can prevail in invalidating the special assessment. Now, is that considered a win? Well, I'll tell you what the association does after we win the lawsuit. They pass the assessment appropriately. So once we've highlighted to them why the assessment was improper, okay, and we prevail in court, they just go back and fix the issues and reassess the homeowners. So special assessment disputes, even though you can win in court, ultimately at the end of the day, the association can oftentimes get it right. And so it's very difficult to prevail on any special assessment issue. In addition to that, oftentimes these types of disputes have to be asserted in a derivative capacity. And we've been involved in several derivative shareholder actions, and part of the process of a derivative shareholder action can be for the association to select an independent panelist. And I must say, I have not once ever seen a situation where an independent panelist rules in favor of the homeowner and not the association when writing their report. And judges oftentimes will defer to that report on the findings of the independent panelists. So any type of special assessment dispute or any type of derivative shareholder dispute where the harm is to the community at large and not so much one individual homeowner, those are very difficult to prevail on. The reasons being that the association can either fix the issue or it's very hard to find or to have a court appoint an independent panelist that will side with the homeowner. And the reason why is because the standard when it comes to derivative shareholder actions, the standard is the homeowner's lawsuit in the best interest of the association? It's hard to make an argument that suing a board member or suing the association is in the best interest of the association. Conceptually, a lot of independent panelists, when they're appointed to these cases, they don't quite understand long-term versus short-term benefit. Sure, in the short term, maybe it's not in the best interest of the association, but in the long term, it's definitely going to be in the best interest of the association if you remove a board member that's doing things that are not benefiting the association and not benefiting the homeowners and causing damage to the association. So these two types of cases are very difficult to prevail on as it pertains to disputes with the community associations.
Natalie asks, what real consequences, if any, do HOAs or condo associations face when selective enforcement is proven in court or arbitration?
So what they face if you prevail in court and selective enforcement, and once again, we've handled hundreds of these cases. It's a very intense factual inquiry. If you're going to sue an association for selective enforcement, you better have photos of your neighbors committing the same violation, and you better have everything documented very well, because judges are going to want to see that when you're asserting it as either a defense or either as proactively as a cause of action against the association. But ultimately, the relief you have is, number one, an injunction. Okay, you can get the association to stop doing what they're doing by getting a court order enjoining them from it. Okay, secondly, this isn't necessarily a benefit to a person that's in this sort of situation, but you can get your attorney's fees back for having to fight with the association. As I mentioned, all of these disputes by statute and oftentimes by contract have prevailing party fees. So you can stop the association from trying to enforce something they shouldn't enforce on you. You can recover your attorney's fees. And if you have any damages as a result of the association's damages, when I say as a result of the association's actions, and when I say damages, I want to be clear with what I mean on that. I mean economic damages. If you have money you have spent out of pocket because of the association's actions, let's say that you removed a fountain that you didn't need to remove because the association was selectively enforcing the rule on you, and you had to pay a contractor $3,000 to remove the fountain. Those are damages. Those are economic damages. But I'm often asked questions about loss of enjoyment, pain and suffering, inconvenience. Florida has something called the impact rule, which does have exceptions to it. But generally speaking, if you're going to sue for pain and suffering and inconvenience and mental anguish and all of these sort of kind of non-economic damages, you need to have some sort of physical contact that occurred. So cases where you can do that are going to be cases where the board president or member of the board physically attacked a homeowner. It would have to be something to that extent. If it doesn't have that, there are exceptions that apply, but the standard is very high to get to those exceptions. It essentially, in most circumstances, has to be egregious conduct. It has to be extreme and outrageous conduct that the board is participating in and causing harm to the homeowner. So generally speaking, what's the relief a homeowner can get? You can get economic damages, you can get your attorney fees back, and you can get an injunction stopping the association from enforcing a rule they should not be enforcing on you.
Dana asks, if water enters my unit and causes damages, would liability fall on the HOA or on me or my insurance?
So it depends on where the water is coming from. And it's important to note that within an association, there's three different types of property. There's unit owner property, there's common areas, and there's what's called limited common elements or limited common areas. So step number one in the analysis here is identifying where the water is coming from. If the water is coming from a common element or common area or something as per the covenants that the association is responsible for maintaining, then they are liable. They are liable for the damage to your home, okay? If the damage is coming from something that belongs to you, that is inside your home, let's say your refrigerator is leaking, or your dishwasher is leaking, or your air conditioner is leaking, and water is coming onto your flooring and damaging it, well, the association is not going to be held liable for that because that's inside of your home. That's unit owner property. And ultimately, that is the type of thing where you do want to call your insurance and report the claim and try to get the money that you need to make repairs to your home. But if it's coming from a common area or something the association is responsible for maintaining, and it is causing damage to your home, I tell homeowners this all the time: the association is the entity that should be paying to fix that, not your insurance company, okay? And oftentimes, the association will have insurance, and the association won't even pay for it. Their insurance will pay for it, okay? They'll open up a claim with their insurance carrier. The insurance carrier will come in and what's called defend and indemnify the case. And ultimately, when the case settles, the money will come from the insurance carrier for the association, which can be a positive thing because ultimately the money will come from the insurance company, and so the association will not have to use the common fund to pay the homeowner for their damages. So ultimately, at the end of the day, the most important thing is, where is the water coming from? If you are uncertain, you need to hire either a leak detection company or a forensic engineer to tell you where it's coming from. And once you have that, you basically have everything you need to file a lawsuit against the association.
I think the last question we have here is going to be from Robin. He says, my HOA board has not changed since 2009. Father and daughter are the president and vice president. Is this acceptable?
So it depends on what type of association you live in, but the statute was amended not too long ago, and it created 8-year term limits, I believe, under Chapter 718 for condo associations. I would have to go back and double check, but I do not believe that Chapter 720, the Homeowners Association Act, has that same language in it. But they more recently, you're going to want to look to the statute depending on what type of association you live in. But I believe there are 8-year term limits that began a few years back. Now they're not retroactive, so it's 8 years from the day the statute was passed. So you're going to want to go back and look to the statute, look to what type of association you live in, look to the statute, see if there are those term limits. But generally speaking, you can be on the board as long as you continue to get voted in, as long as you're not violating the statute. And Catherine, I think we have time for one or two more. Let's answer a couple more questions.
Perfect. Sounds good. Edward says, what about disputes over financial reporting? Is this able to be brought successively as a lawsuit?
So it depends on what type of dispute regarding financial reporting you're talking about. So if the association is simply not turning in their financials to you, absolutely, that's a violation of the records inspection portion of the statute. And those, as I mentioned earlier on, have a very high probability of success. Now, if what you're talking about is a misappropriation of the common fund, which essentially means the association is improperly spending money, now you're talking about something that has to be likely brought in as a derivative shareholder action claim. And within the association context, there's something called the business judgment rule, okay? And it's somewhat complex and a little bit difficult to understand, but generally, what the business judgment rule says is that board members have some discretion to make decisions for the association, particularly financial decisions, as long as they comply with the statute and the governing documents. They do have some discretion to make decisions. So, for example, there may be a landscaper that provides landscaping services for the association. There's one landscaper that charges $5,000 a year, and there's another landscaper that charges $7,000 a year. The board can select which one they want to use, and they may want to use a $7,000 landscaper because the quality of the landscaping is better than the landscaper that charges $5,000 a year, even though the $5,000 a year landscaper is cheaper. So the board does have discretion to make decisions based on their business judgment. If you believe the association is misappropriating the common fund and misspending money, you will very likely have to file a derivative shareholder action. And as I mentioned, if it is not an egregious violation that clearly violates the law, prevailing on those sort of cases is extremely difficult because of the panelist appointment process. It's very hard to get a panelist to side with the homeowner when they're completing their report. Let's do another question.
If the president, without official action, orders the property manager to not allow repairs due to former code violations and denying the well-being of the owner's family and use of facilities, can the president be held liable?
So as I mentioned earlier, the primarily liable party in these sort of situations is going to be the association as a corporation, as an entity itself. Now, if the board president went out of his or her way to stop repairs to a homeowner's unit and there's evidence to support that, the board president may be held liable. Absolutely. Same thing with the property manager. If the property manager took actions specifically to inconvenience a homeowner, and ultimately that caused damage to the homeowner, the property manager could be held liable as well. In these cases, there's the law and then there's the practicalities of real life. Okay. Sure, in any dispute, you can potentially name 2, 3, 4, 10, 20 defendants that have some liability. Okay. But if you name 20 defendants, okay, that's 20 different depositions. That's 20 different sets of discovery. Okay. That's 20 parties that have to appear at trial and need to be available for trial. And so in these cases, you want to be as efficient as possible. You want to be made whole as efficiently as possible. Okay, there's many different ways to get to the ultimate goal, but at the end of the day, you want to get there as quickly and efficiently as possible. So when evaluating your case, if you can sue the property manager, if you can sue a board member, if you can sue the association, you're going to want to consider, is it worth it? Okay, is this going to require the case? Is this going to force the case to take much longer? And if the answer is yes, it may not be worthwhile to sue them. If the answer is no, and you believe that you can be made whole through suing the property manager, then yes, then you are going to want to sue the property manager. So very good questions. Let me jump into the next slide here as it pertains to the presentation here. Bear with me just one moment. So thank you everyone for participating in this Q&A. I think they were all excellent questions, really good questions that clearly there was some thought put behind them. Interesting issues that homeowners are facing, and I hope I was able to provide some guidance as it pertains to the questions. I want to let you all know that we will definitely be doing this again. We received over 100 questions. Very hard to answer 100 questions in an hour, but we will absolutely be doing this again. This will be posted on our YouTube. So if you asked a question and you would like to listen to the answer again, or if you had a similar question but you didn't hear the answer, jump on our YouTube and you'll be able to see it there. But once again, we will be doing this again. We will be asking for questions in advance. We will likely be doing this monthly, so there should be plenty of opportunities to answer everyone's questions. I've put our contact information on the screen here. If you have a specific question and an issue involving your association and a particular case that you'd like to discuss with us, I would encourage you to give us a call. Okay, this is our phone number. This is our email address as a law firm, info@pmlawfla. You can also go on our website and submit your inquiry. That is probably the fastest way to get a hold of us and set up a consultation. We offer consultations to everyone who calls us, and essentially there's 3 different kinds of consultations you can have. As I mentioned, for property damage cases, leaks that have damaged the inside of your home where you're looking exclusively for the money that you need to make repairs, we do offer those cases on a contingency fee basis. So we do offer a free 15-minute consultation for property damage disputes. Everything else is going to require either a 30-minute or 60-minute consultation simply because those issues are more complicated. They require more time. They're more nuanced, more explanation. So if you would like a 30-minute consultation, we offer those for $195. If you would like a 1-hour consultation, we offer those for $395. We also offer in-person consultations if you'd like to visit our office and come in person to discuss your case. We only offer 1 hour for the in-person consultation simply because things take a little bit longer when you're in person. So feel free to reach out to us to get your questions answered and have a consultation with us. I look forward to answering more questions in the future. We represent homeowners throughout the entire state of Florida. We have offices in Miami and Tampa as well. So whether you're in the Panhandle or all the way down in the Keys, we can help you. We can represent you against your association. Please feel free to reach out to us. We are dedicated, as I mentioned, exclusively to representing homeowners against their association. And this is not only in a legal context. We also participate in many events political events to advocate on behalf of homeowners. We have several representatives that we meet with to try to get legislation changed to make it more favorable for homeowners. More recently, the new proposal to Chapter 720, which has been seen on the news more recently. They have reached out to us to opine on it and make changes on it and see if we can try to incorporate additional things as it pertains to the new House bill that's been proposed. So please feel free to reach out to us if you'd like to discuss your case or just generally how the new laws may affect you. We can provide you with a consultation on that anywhere if you're anywhere in Florida. And lastly, if you found this seminar or webinar rather and Q&A to be helpful, please feel free to leave us a review. It does help other homeowners find us, and a lot of homeowners out there don't really know where they can look to for guidance. And the more visible we are online, the more likely that they can find us, and that way they can attend these sort of webinars and get more information and find out how to protect themselves. At the end of the day, we want to advocate on behalf of all homeowners. We're on a mission to educate all homeowners and advocate for all homeowners and try to even the playing field as it pertains to HOA disputes. At the current state of the law creates situations where homeowners oftentimes are at a substantial disadvantage as it pertains to disputes involving their association. So we need to attack on all fronts, not only within the courtroom, but also within a political context, within any business context. Homeowners need to be advocated for, and there needs to be changes in legislation, and their rights need to be preserved. So if you can leave us a review, it'd be very much appreciated. We're going to be sending an email to everyone that attended with the link where you can leave us a review. And we will also be sending to everyone via email the link to the YouTube so you can rewatch this Q&A. But it was a pleasure to provide this information to everyone. As I mentioned, for those of you that didn't get your question answered, don't be discouraged. We had over 100 of them. We will do this again. Please submit your question to us. And when we do the next Q&A next month, we will have several preliminary questions and once again open the floor to live Q&A. So I hope everyone enjoyed this. I hope everyone has a happy and healthy holiday season. And I look forward to seeing you all next year. Take care.